Hi candidate attorneys, hello, welcome back to my channel. Igama ngu AsandaNtini and welcome to this video. If you are new here, I am an admitted attorney and I share content specific mostly for candidate attorneys and people that are interested in the legal profession. None of my videos constitute as legal advice. If you are looking for legal advice, consult, do a proper consultation. It doesn't have to be with me. You can consult with anyone who is a legal practitioner, pay their fees, and you'll get your advice. Anyways, let's speak about unfair dismissals. I'm not sure if I've done a video on unfair dismissals, but if I haven't, this is it. You're approached by a client. I'm doing this video because mostly in January, a lot of people are usually January and end of December or December. I'm having this. Comment down below if you like this flavor. I don't. Maybe it's an acquired taste. I should try it again next time. Anyways, back to what I'm speaking about. Dismissals. So you are being approached by someone, a client or a potential client or somebody who's just, those quick questions people. First things first, what they need to establish is that they actually have been dismissed. So if this person is saying, I haven't been to work since the 10th of January, and they're coming to you today on the 24th, that's 14 days. I'm going to get you to why I'm mentioning that that's 14 days. I haven't been to work since the 10th. My employer said I must go. Need to establish, do they have a termination notice or their employer just said you must go and then they decided not to go? And if their employer, have they tried reaching out to their employer asking did they mean go, I'm dismissing you from your employ, or did they mean just go? I don't want to see you right now. You are suspended, whatever the situation might be. You need to establish the relationship and the ways of communication that usually goes in, because you have to have had a dismissal. Otherwise, some employers pull the card off, this person absconded, and some get away with it, but some don't, because obviously, in order for you to say that a person has absconded, you as the employer should have tried to get them to come back to work or ask if they are actually still in your employ. Okay, so that's the first thing you need to establish from somebody who's coming in to consult with you. Are you actually dismissed from work, or you just ran away from work? You just absconded, you just decided you're not gonna go? Because the many reasons why people get obviously dismissed, and some of the reasons are some people are easy on the hands and end up going like being caught, and then they just don't have inquiries. All of those things are unfair. So those things established an unfair dismissal, which is my next point, which leads us to my next point. So the person has been dismissed. Now you must establish, was this dismissal fair or unfair? How do you establish that a dismissal is unfair? Was procedure followed? Was the reason for the dismissal a fair reason? Is it misconduct? Is it misconduct? Is it statutory requirements of the employer? Is it performance issues? If it's performance issues, also establish if the employer has done everything they could to prepare or train this person. You need to then establish with the employer if they've actually done anything to make sure that this person actually is able to perform their duties. So then, is the dismissal substantively fair? And then in terms of procedure, was there a hearing? Did this person get told that they're going to have a hearing? Okay, yeah, there's space issues. Anyway, so I was still saying that if the next thing you need to establish, was proper procedure followed, because a dismissal is either substantively unfair, like the reasons for the dismissals are just shady, basically, and then procedure wasn't followed. So certain procedures, sometimes in the employment contract it's set out, but the standard one would be to have a hearing, have an outcome. Person in the hearing is allowed to bring witnesses and also lead evidence, cross-examine on the evidence of the employer and all of that. And then an outcome is given, and then they are given an opportunity to appeal. By appealing, usually they would say take it to CCMA or any other forum that governs you. Anyways, yeah, so establish if that has happened and if that hasn't happened or not. Then once you've established as a candidate consulting or as somebody consulting, you are then going to say, okay, I can see that there is potential in this case. So what I'm going to now do is ask the following questions. What do you want from your employer? Do you want reinstatement? Do you want compensation? Whatever it is, you need to establish your instructions from your client. What is it that they actually want? 2, you need at the top of your head have the timelines in mind. Labor law has really strict timelines. If you are submitting a matter for an unfair dismissal, you must file it for conciliation within or conciliation within 30 days from date of dismissal, and not 30 court days, but 30 days. So the day, if the person was dismissed on the 10th, you must have filed before the 9th the following month. Otherwise, they're going to ask you to apply for condemnation, which they can grant or dismiss. So you establish all of that, and then you put it in. Now CCMA is online. I usually just do it online while consulting with the client. If I see that, okay, this actually needs to go to CCMA, that's what I usually do. Or if they don't want to go to CCMA, they just wanted advice, then you give them the advice as to what's going to follow, advise them of the timelines. And then if the matter has gone to CCMA for conciliation, your next step would be arbitration if the matter didn't proceed as a con-ab, which you must file within 90 days from date of first sitting. And then also, if 30 days has passed after having filed a notice for conciliation, but you haven't said, you have a duty as a practitioner or as a person who's applying for a sit down at CCMA. You must apply within 30 days from receiving from reporting the matter. You must apply for the 90-day arbitration matter. So you must file the 713 form. The 711 is the one that you file for your conciliation or con-up. Anyways, yeah, that's how it goes. And then at the commission, or whether you are at CCMA or whether you are at like whatever the arbitration body it is, you actually, as an attorney or as a legal practitioner, are not allowed to represent your client within conciliation, but usually commissioners allow you to sit in and just listen, because at that stage they are just speaking to each other. So don't be alarmed if they ask the other party, being the employer, do you mind that an attorney is present? Do you have an objection to that? Some object, but usually people that object to that are usually those union members that act like comrades and start speaking English like they are from times of Steve Biko. Anyways, yeah, so that's what happens in conciliation. Then arbitration, you have to adhere to Rule 25 of the CCMA rules. Google that. If the matter was of misconduct, not just Google, research that on the CCMA rules, read on that and hear what it says. Because if the matter is now going to arbitration and it's a misconduct matter, you don't have an automatic right to appear for your client. So keep that in mind. And if your client has come through and was dismissed for misconduct, you don't automatically come in and say, I've prepared arbitration, I'm here, let's hear my matters. No. Sometimes it actually needs you to apply in terms of Rule 25, and that can be granted or dismissed because some matters don't need practitioners in terms of the CCMA rules, and you will then only be approached once you are now appealing or sending the matter on review. With that said, I hope you enjoy your consultation with your client. If it's your first consultation, keep calm, listen to them, and listen to them very carefully, because a matter of employment, especially a dismissal, makes you make decisions like taking the matter to CCMA when there's no prospect, when the person is basically just throwing straws at something that will not succeed in any way, but they continue wanting to go to CCMA. With that said, I hope you have a blessed year. I've been saying, I think now that I think this will be the last video in January. Okay, maybe there will be one next week before end of January, but this is the last time I'm wishing you all a very great year, great start to the year, because I know that we are going to have a good year. Anyways, yeah, lighting is getting worse because weather is just not summering. Anyways, love you lots, and I will see you on my next video. Don't forget to like, comment, and share this video. Bye.